Hello everyone and welcome to today's Mondac webinar in association with Victoria Associates and an expert panel who will be discussing strategic approaches to complex disputes. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Duarte Henriques is a highly regarded Portuguese lawyer recognised as a thought leader in arbitration by Who's Who Legal. Highlighted in WWL Arbitration 2017 as a prominent figure in Portugal, he is acclaimed for his deep expertise in commercial and investment treaty disputes. Known for his strategic counsel and exceptional insights, Duarte is sought after for his ability to navigate complex international legal challenges. With a strong reputation for delivering favourable outcomes, he consistently provides trusted advice and effective solutions, cementing his role as a go-to legal authority in the field of arbitration, both locally and internationally. João Frazio is a qualified lawyer in Portugal, admitted to the Portuguese Bar Association in 2016. Currently pursuing his PhD at Nova School of Law, his research centres on space law, international law and European law. With a strong academic foundation and practical legal experience, João is dedicated to exploring complex legal frameworks governing space activities and their intersection with international and European legal principles. His commitment to advancing legal scholarship in these specialised fields reflects his passion for addressing emerging legal challenges in today's dynamic global environment. Rita de Carvalho is currently a trainee lawyer at Victoria Associates since September 2022 and is set to qualify as a lawyer with the Portuguese Bar Association in the summer of 2024. She also holds qualifications as a mediator, recognised on the Portuguese Ministry of Justice list of mediators. Rita earned an LLM in litigation arbitration from the Nova School of Law and has been serving as the Executive Director of the Nova Dispute Resolution Forum and Nova Knowledge Centre since November 2022. Her research predominantly focuses on international arbitration and alternative dispute resolution, showcasing her dedication to advancing expertise in these fields. Now, before I hand you over to our panel to begin today's webinar, a quick housekeeping item. You're able to submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we do encourage you to get your questions in. We endeavour to answer as many of those as possible. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thank you, Dan, and the whole Mondac team for organizing this webinar and for your tireless support in organizing this. It's always a pleasure, great pleasure and honor to be speaking about this topic that I love so much, which is the international dispute resolution and more particularly international arbitration. Well, for today, we're going to address several topics in international dispute resolution realm. And the first one, we'll be discussing issues related to arbitration and other methods of resolving disputes in the business and shareholders matters. And also we'll try to address the phenomenon, the recent, relatively recent phenomenon of third-party funding in international dispute resolution. And then we'll move to a very hot topic and a new topic in the international dispute resolution realm, which is space regulation, and disputes in space law. And finally, we will address our topics in investor-state dispute settlement, especially in what the environment interests are concerned. So, first of all, the first topic is how to resolve shareholders' disputes while safeguarding this business continuity and maximizing shareholder value. In a way, how to control damages to the business when a dispute arises. The first question or the first concern that we must have here is before the dispute arises, and has to do with the question what to do to prevent disputes from happening or from escalating. The first point and the first advice I will give is to whenever you have a business transaction or you're a shareholder in a company where there's some sort of balances and forces, you should have a proactive governance and clear agreements in place. And for that, you should implement strong shareholder agreements. Ensure that clear shareholder agreements are in place from the outset, covering key issues like decision-making processes, dispute resolution mechanisms such as arbitration, and exit strategies. Sorry. It should also have effective corporate governance, establish well-defined governance structures, including clear roles for the board and management to prevent disputes from escalating, and have a comprehensive risk assessment. Highlight the importance of conducting throughout financial, legal, and operational due diligences to identify potential risks early in the process. What to do to prevent disputes from happening? You should also have early identification and mediation, adopt a proactive conflict resolution mindset, encourage open communication and early intervention to address potential conflicts before they escalate into disputes. Mediation and ADR mechanism. Use alternative dispute resolution methods, such as mediation or arbitration, to resolve conflicts without costly and time-consuming litigation. Have in place valuation and buyout strategies is the third concern that I would raise. A fair valuation mechanism in cases of shareholder exit ensure that fair and transparent valuation processes are in place, which lead to minimize disputes over the share of the value of the share. Have also a structured buyout options. So in the agreements that you have in place, design flexible buyout arrangements, including put and call options that offer clear paths for exiting shareholders without destabilizing the business, which is truly important. Also, as a fourth advice, I would say that leverage independent experts and advisors from the outset before the dispute arises or escalates. Have in place third-party neutral advisors in complex disputes. Bring in independent experts or advisors to provide unbiased opinion and facilitate balanced resolutions. And board oversight committees. Establish specialized board committees to address shareholder concerns, ensuring that the disputes are handled with diligence and fairness. When the dispute starts to surface, we should adopt a crisis management and business continuity plan so as to avoid any kind of disruption on the business day to day. You should have a dispute impact assessment, assess the potential impact of disputes on business operation and continuity, and prepare contingency plans to mitigate risks. Have also in place interim management solutions. In severe disputes, consider appointing an interim manager or independent director to maintain stability and ensure smooth operations. And lastly, use dispute resolution mechanism. Highlight the importance of pre-agreed dispute resolution mechanism, such as arbitration in your M&A agreements. The main goal is to resolve, as I said, a dispute without disruption of the business. Otherwise, the business will collapse. We all know this story from the experience that we have in courts. We are currently advising here clients in shareholder disputes, and the outcome of it is an escalated dispute, which has eventually led to the collapse of the business. So you should have in place methods to avoid this escalation and this disruption, and use those mechanisms that can be kept apart from the day-to-day business. So negotiation and mediation techniques that can be embedded in the process is always advisable. In these kind of alternative dispute mechanisms, you have a third neutral that is going to conduct the negotiations between the parties or mediate the parties in order to reach a settlement that is fair and balanced for all the parties. Also, aligned with this, you can use appointed independent experts to determine the illicit, the causation, and damage. And lastly, you can or should or are obliged to resort to arbitration. So, what is actually arbitration? Arbitration is I should say, a contractual mechanism to solve disputes that arise along the way of an agreement or a shareholder relationship, and it's private by nature, but produces an outcome that may have some public uh, protection over it, which is the award. So it will function as it was a court judge to produce a decision, but instead is made by private arbitrators. This method allows you to tailor-made the process, make the process so you can have a certain set of rules that are specially tailored for the needs of the parties and for the specificity of the process and of the dispute. You can also have, and is a second, what I would say, a second advantage of arbitration. You can have experts appointed to serve as decision makers. So if you go to a court, a state court, you will eventually end up in the hands of a court judge who has not any experience in the field of the law, where the dispute has arisen and where it needs some kind of expertise to decide the dispute. On the other hand, awards made in arbitration are in principle final. So, except for rare cases of challenge and nullity of the arbitral award, is final and subject to no appeal. It can control the costs and time. When you have an arbitration in place, you can control the time and the costs associated to this procedure. Um, it is also a mechanism that will produce an award, a decision that virtually is enforced worldwide. In fact, arbitration is more or less covered by the New York Convention of 1958, which allows for the recognition and enforcement of arbitral awards in all the states. And today, as of today, almost every state is party to the New York Convention. So this allows you to have an award that is enforceable wherever the debtor of the award has assets. And finally, I would point out a great advantage of the arbitration process, which is the confidentiality. Arbitral awards and not arbitral awards, but the arbitral process and everything that goes on it is confidential by nature. So it can keep you from being exposed to the public about the dispute and the nuances and the things that are said in those disputes. So this will be the advantages of using arbitration. But of course, there are some disadvantages attached to arbitration. One is for cost. If you do not have proper clause in place, the cost can skyrocket. And the second challenge is the growing challenges on arbitrators. And the third one is due process paranoia and excessive regulation. So nowadays, you'll find many arbitrators who have this so-called due process paranoia, and excessive regulation may apply to arbitration, which turns the arbitration proceeding a bit complex and more complex than was expected to be. And finally, there's a disadvantage when it comes to listed companies, because in cases of listed companies, it is not possible to have arbitration agreements in place, at least in the sector of or in the area of the relationship between the shareholders and the company itself. So I would now address and finally, because I see that my time is running, I will address the role of third-party funding in international dispute resolution, and more particularly in international arbitration. What is third-party funding? Simply put, it's a mechanism, a financing mechanism, upon which a third party will bankroll and provide the financing for all the costs of the arbitration or the case, if the case is running in state courts. and will pay, so as I said, it will pay all the costs against a proceed or a share on the proceed, or a multiple calculated upon the amount of the money that has put in the investment. So if the claimant succeeds in his claim, the funder typically will see as his retribution a portion, usually 30%, 40% of the proceeds of the claim, will get as retribution those that share. Alternative, the funder can have a multiple calculated upon the amount of money that they has put in the case. For instance, for every dollar or euro that he has put in the case, he can receive back 3 or 4 euros, or US dollars, wherever the currency has been stipulated. So this mechanism is increasing in popularity and prominence. We at Victoria Associates have been dealing with third-party funders, and we have been having cases financed by third-party funders, and we find it particularly beneficial to, especially when it faces parties with scarce financial resources, but also in other instances, like companies that want to use this as a set off of their balance sheet and use this as a finance management tool. Um, the the uh, the most, I would say, the most prominent feature of this business model of financing is that it is a non-recourse funding. That is, if the claimant does not succeed in the claim, the funder will not be reimbursed for his investment. So it is more or less for the parties who are financed a win-win situation. Today, the funding is made through or via the single case funding or portfolio funding. There is, the funder will finance a single case on a case by case basis, or you can fund an entire portfolio. This is very common to happen in large law firms, especially in the US, where third party funders play an important role in financing the whole portfolio um, of the law firm. In international arbitration, this involves risks and challenges, as it can raise issues of conflicts of interest between the parties and the funders and the arbitrators. And so there are many concerns about this, and usually and currently it is almost set in stone that the parties must, if decided by the tribunal, disclose the existence and identity of the third party funder, sorry. And sometimes arbitral tribunals do also request from the party to provide details on the financial arrangements. The other concern that typically may arise in international dispute resolution and international arbitration is about the ownership of the claims. If the financial arrangement is not properly negotiated and executed, this may bring some sort of control from the funder of the case. Of course, if you talk to any funder, they would say that they do not control. They simply exercise an oversight of the case. But in practical terms, I think that it's mostly or most of the time it's impossible to distinguish between what is the control of the claim and what is merely an advice and a supervision of the claim. But with that, I stop here and will pass the floor to João, who is going to address the issues in space law. Thank you so much.
Um, Thank you, Barty. I think everyone can hear me. Good afternoon, everyone, to all the participants, and thank you to the Mondac team for this pleasant session. It's an honor for me personally and for us as a team to be here. I'm going to try to meet the 15-minute target, so I'm not going to be excessively exhaustive, not least because time does not allow it. We have already an excellent overview from an expert like Duarte, whom I would like to thank, and I think we have important materials and important details for us and for you to discuss later on. But in fact, like any other topics, space and in general space law has enough to talk about for at least a week. And why is that? Because it's space. So I'll try to reach a few topics, and again try to meet my 15-minute target. I'll be going through the international treaties just to give you a few details, then addressing the suitability of arbitration, the disputes, types of disputes, a couple of examples, and a few final comments regarding this broad area of space and our recent experience from an international point of view. So, without further delays, space law. When we talk about space law, we talk first and foremost in international treaties. Space law was based and was constructed since the late 50s with the launch of the satellite Sputnik of the former USSR, and since then we have a body of international treaties that regulates space and space activities. But like you can anticipate for sure, treaties that were discussed, drafted, and adopted in the 60s and the 70s were very state oriented because at that time it was pretty much impossible to anticipate that private entities would be in space. So we have a basis of space law, which is the Outer Space Treaty, and then we have additional treaties that complement and develop specific clauses, specific articles from the Outer Space Treaty in what concerns registration, liability, um, providing assistance for astronauts, and so forth. So, Outer Space Treaty indeed provides that states and not private actors are in fact, amongst other things, internationally liable for damage caused by objects launched from their own territory or more than their territory, but their territory and their jurisdictions, and for activities in general conducted in space, regardless whether those activities are conducted by a non-governmental organization or if they are pretty much conducted by a formal traditional agency like we have, for example, in the United States, in Europe, in Russia, in China, and so on. But like mentioned, when these rules or while these rules were created at a time that primary actors in space were, in fact, the US and the former USSR, we have now hundreds of private entities operating in the space industry. And in fact, I don't know if everyone here is aware of this fact. We have a very well-known private company called SpaceX that has a mega constellation, and it's the entity with the most number of satellites active in orbit. We have Starlink that now have reached the milestone of 7,000 satellites in orbit. So things are quite different from what they were even 10 years ago. Of course, even more different than they were 50 years ago or 60 years ago. So the general rule regarding damages and arbitrations, because that's what it matters for today's discussions, is that in fact, if a private entity wants to pursue on an international space law level another state, it has to go through its own state, meaning its state of registry, to act diplomatically on its behalf. Likewise, the liability convention, which further developed the provisions uh, um, laid down in the Outer Space Treaty, defines, amongst others, damages and damage from a collision perspective. It was the first time that a treaty introduced a bodily damage, let's put it this way, to a loss of life or an injury suffered by a specific person or people, or material damages. The liability convention included very important details. I can highlight a couple of them, which is the system of liability. We have an objective or absolute liability for damages caused by space objects on the surface of the Earth or to an aircraft in flight, and a subjective liability based on fault, that is, damages being caused elsewhere than on the surface of the Earth. Um, In fact, I don't know if you were aware, but we had this news that a component from, I think, the International Space Station landed in a household in Florida in their backyard. So in that case, that private person could knock on a door to the Department of State, I presume, and to ask to start a diplomatic approach with the third country that would be identified and responsible for such damage. The liability convention includes a claims commission, sorry, that works through those diplomatic channels. But to this date, a liability convention was approved and entered into force back in the 70s, was triggered just once, and this was a satellite from 1978, if my memory serves, when a former Soviet satellite crashed on Canadian territory, and Canada issued a claim against the former USSR. But at that time, the dispute was eventually resolved uh, amicably through those diplomatic channels. So, as of these days, as of today, we do have important new actors, a new landscape, and of course, there was a need to update and to create, in fact, mechanisms to address different types of disputes that arise or may arise from space activities. Examples may include, for example, allocation of satellite frequencies. In that case, multiple satellites can share the same frequency range if they employ techniques like geographical separation, time division, or in order to prevent interference, or in case of orbital slots, or notably the ones in the geostationary orbit, which are distance of 36,000 kilometers away from the Earth, because those satellites are static, and those orbital slots are granted or allocated by the ITU, which is the International Telecommunications Union. And those member states of the ITU member states, which are, of course, the members of the UN, in turn can assign such rights to private entities or private companies in their own jurisdictions. But in fact, as the landscape has evolved and changed, we can indeed have numerous events that could have present or future disputes, because it goes without saying that if the number of actors in space is gradually rising or exponentially rising, it will soon result in more disputes. It's inevitable. Examples of those disputes may include those based on collisions, on satellite-based related disputes regarding any components from the space industry, from manufacturing, from launching and operating specific satellites or space infrastructures, or even disputes regarding to the launch of space objects into space orbits. But we can, of course, encompass more traditional or more well-known domains such as regulatory, insurance, or even IP right domains. So um, space disputes are indeed numerous, or maybe numerous, but are indeed diverse and complex, which may include, again, states, private actors, or both. So we have pretty much two conclusions or two important details that pretty much tells us what are or what can be those types of disputes, which are per se international and multidisciplinary. In this context, in recent years, we have witnessed the emergence of ADR, alternative dispute resolutions in space, or to space disputes. A couple of examples are the Permanent Court of Arbitration, or is a Permanent Court of Arbitration that adopted its permanent court rules to space disputes. And recently, in 2021, Dubai has established its own specialized space court. Although those are not the most known well bodies to deal with these issues, but in fact, we have witnessed and we know for a fact that to resolve these disputes, other arbitration channels have evolved. Practice tells us that, for example, international contracts have usually used an arbitration clause, and this happened, for example, in the procurement from the European Space Agency, which prefers arbitration in its smaller contracts for a few time now. So we have, of course, international arbitration mechanisms. A few of them, I think, Duarte has already mentioned, and you, of course, are well known to the International Chamber of Commerce or the London Court of Arbitration. We do have, especially regarding on investment treaty arbitration, we have seen and we know decisions regarding space disputes in the perimeter of investor-state dispute settlement, existing international rules, including UCITRAL or the ICSID, which are of course quite important in the international arena. We do have, for example, state-to-state arbitrations. So to the extent that there may be a state-to-state, let's put it this way, dispute regarding space, and in that event, the International Court of Justice is well established, and everyone is waiting for a decision of the International Court of Justice regarding space or a possible damage or even something worse than space. We don't have it to date, but this is, of course, a mechanism available to states. Apart from this, of course, we do have other or may have other kinds of disputes, such as private state disputes arising in public international law, in the context of disputes that may arise between a private company or an individual and a specific state. So we do have different scenarios that could help resolve disputes in on the basis of arbitration outside of the perimeter of those international treaties that were enacted back in the 60s and the 70s. A few examples just to tell you that seen over the last decade and a half, we've been witnessing, especially those treaties, those disputes that have a relation with investor protections to investments in space. We had a couple of them, for example, in 2012. At that time, there was or is a dispute that was between the Mauritius company Davis and the state of India. The arbitration rules adopted were the UNCITRAL ones, and the institution was the PCA. The summary of that dispute that was decided in 2016 concerned claims arising out of an alleged India government's cancellation of an agreement to lease capacity to a specific allocation frequency of the electromagnetic spectrum for claimants, a subsidiary of two satellites. And at that time, the breaches found were in fact an indirect expropriation and a violation of the fair and equal treatment by the state of India. More recently, we have a case of Eutelsat against Mexico that was initiated in 2017, and it was based at this time on the ICSID arbitration rules. It followed the ICSID proceedings, and the seat of the tribunal was based in Madrid. The relationship or the disputes of the details of the dispute was between a French telecommunications company, Eutelsat, that brought a claim against the state of Mexico, and in a nutshell, pretty much requiring Eutelsat to reserve a greater amount of their satellite megahertz capacity, and that the claims were pretty much dismissed. And according to recent news and the decision from the Mexico government, the tribunal dismissed those claims, and the costs were awarded to Mexico. So these are the most common kinds of disputes regarding investor protection in investments regarding space activities, telecommunications, orbital spectrum, orbital locations. But indeed, and without violating my 15 minutes, a final comment just to stress on the basis of what Duarte has already anticipated. Indeed, we have clients in the aviation industry, and we have been involved with a few space activities from different operators, both assisting those operators, but also in the contact with the regulatory authorities in Portugal. Although our market is relatively small, it has been experiencing an expanding and rapidly growth over the last 3 to 4 years. But in order to do that and to be able to assist in these kinds of disputes, it it is, in our perspective, essential to aim for an international dimension in these kinds of disputes and its resolution. This is a major focus of our firm. And just to give you two very quite recent examples, we have participated in international events with our colleagues and partners who told us that in fact disputes are getting more multidisciplinary and more technically complex. And we had that experience from the International Bar Association Arbitration Day that took place in Lisbon, which we sponsored, and last June in the London International Disputes Week, where in fact space and space arbitration had a dedicated topic and discussed space activities in general, the challenges to private actors and states and international organizations. So this is the scenario that I wanted to give you. I hope I fulfilled my 15 minutes. So, Rita, giving you the floor.
Thank you so much, João. I would also like to thank Mundak for organizing this webinar, and thank you all for joining today's webinar. It is a pleasure to be here alongside such an amazing panel and delve into these topics. My part of the discussion, as Duarte has anticipated, will focus on the key developments on the field of investment arbitration. More specifically, we'll delve into the increasing influence of environmental concerns and also the evolving crisis within the EU arbitration framework. The goal of this discussion is to understand these dynamics and discuss what strategies can robust dispute resolution frameworks across EU jurisdictions in our experience. So, as you all are aware by now, over the past few decades, as awareness of environmental sustainability has grown, environmental concerns have begun to play a more significant role in international investment disputes. On one hand, we have investors that are increasingly encountering host states' regulations aimed at protecting the environment, which sometimes can conflict with their business interests. This intersection of environmental regulation on one hand and investment rights on the other hand has generated significant challenge, but also opportunities to align economic and environmental goals. In parallel with this matter, we also have the European Union's approach to arbitration that has been undergoing significant transformation. The regulatory challenges, Brexit's legal aftermath, and the withdrawal of key nations from agreements such as the Energy Charter Treaty, the ACT, the landscape of investment arbitration in the EU is shifting. Today, my goal is to explore how these changes are reshaping the dispute resolution framework in the EU and how companies such as our clients and governments can adapt to these changes. So I believe it's better that we start with a general overview of environmental concerns in investment arbitration. As the urgency of addressing climate change grows, many countries are adopting more stringent environmental policies, including measures to promote renewable energy, reduce emissions, and overall protect natural resources. While these policies are crucial for long-term sustainability, they often can impact foreign investments, particularly in sectors like energy, mining, and infrastructures. For instance, states that once relied heavily on fossil fuels are now pushing for greener energy solutions. This transition, while essential and necessary for environmental reasons, can also lead to significant losses for investments in affected sectors, leading to arbitration disputes. As I'm also sure that you are aware, investment treaties have traditionally focused on protecting the investors from unfair treatment or expropriation. These mechanisms were created to make investments more desirable to foreign players. However, today many of these treaties are being tested as host states argue that their environmental policies designed for public welfare should take precedence over investor rights. This has created, understandably, a growing need to balance the rights of the investors under international treaties with the sovereign rights of states to regulate environmental protection. A prime example of this dynamic is the Energy Charter Treaty, as I mentioned before, the ECT, which originally intended to protect investments in the energy sector, but has now become a true battleground for disputes around environmental regulation. The ECT, therefore, plays a major role in how energy-related investments are governed. But with the current focus on transitioning to green energy, its future is in flux. Ultimately, I believe that the question that we're grappling with is how can we reconcile the goal of attracting foreign investment with the need to enforce environmental protection and a sustainable development? In my opinion, and in order to give you a practical example of how these disputes may arise, I would like to mention two cases where environmental policies have clashed with investment protections, and in this case under the ECT. The first one centers on Italy's decision to ban actually oil and gas exploration near its coastline. This was a part of its commitment to environmental protection. On the other side, we had Rockhopper, a UK-based energy company that invested in oil exploration in Italy. When Italy imposed these restrictions on offshore drilling to protect its environment, Rockhopper filed an arbitration claim under the ECT, arguing that the ban would deprive them from the value of the investment that they've made. The tribunal ended up ruling in favor of Rockhopper, awarding them damages, which sparked some criticism in a, for me, understandable way from environmental groups and also policymakers. In my opinion, this case underscores the tension between the state's environmental goals and the protection of foreign investments under the ECT. Another prime example of this matter is a case that involves Spain. In this situation, Spain had implemented a series of reforms to its renewable energy sector, cutting some subsidies for solar energy investments to address economic challenges. Sharon, an investor in Spain's solar energy market, filed an SCT claim arguing that the reduction in these subsidies violated the protections actually offered to foreign investments. Although in this case, the tribunal ultimately ruled in favor of Spain and recognized its sovereign right to regulate in the public interests, the case also has triggered several subsequent claims. This case, differently from the other one that I've mentioned, highlights how disputes can also rise when the states are transitioning towards green energy, because regulatory changes can lead to claims under the ECT, whether it is for a greener transaction or if it is in cases such as the first that I've mentioned. On the bottom, both cases reflect the difficulty that it is to balance environmental protection on one hand and economic interests in the other. As more countries push through the decarbonization and adopt greener policies, we can expect more cases where investors challenge the impact of these policies on their financial interests. In our experience and how we have been managing these kind of situations near our clients and dispute this and actually navigate these disputes in a more successful way is to a few key strategies that often apply to these situations. Firstly, one approach is that is becoming actually more common is the inclusion of sustainability clauses within investment treaties. We often have seen that when the treaties, the BITs, the FTAs actually include these clauses that specifically address environmental protection and require investors to adhere to environmental standards, normally these disputes can be prevented from happening in the first place. By including these clauses in investment contracts or even in investment treaties, both states and investors can clarify upfront their commitment to environmental issues. A second key strategy is to promote a continuous dialogue. This strategy of promoting the dialogue before a dispute escalates should be handled as a mechanism to communicate regularly about evolving regulations and environmental standards. This helps both investors understand what to expect from the regulatory environment and also allows them to adjust their operations accordingly. A third and last strategy that we think it's important that investors and host states implement is also to make environmental impact assessments, but not as a mere formality as sometimes it is seen. Investors should make these environmental impact assessments as a way to genuinely evaluate and mitigate any potential environmental risks from the investment project. This way, they can align their corporate actions with local and global sustainability goals. As I've said, these strategies not only prevent conflict, but they also foster a positive relationship between the foreign investor and the host states and help to ensure that investment activities also contribute to long-term environmental sustainability. Now, going to another topic, we are going to turn our focus on the broader context of the European Union arbitration. And in this matter, actually, the Energy Charter Treaty has become a focal point of contention. Coincidentally enough, the Energy Charter Treaty was originally signed in our city, Lisbon, in 1994, and was intended to promote energy security and foreign investment protection. But today, it is seen by many as a barrier to climate action. As we've seen in the cases that I've mentioned before, the treaty's investment state dispute settlement mechanism has been used extensively by fossil fuel companies to challenge green energy transactions in countries like Spain, but also Italy and the Netherlands. One of the key crises unfolding is the withdrawal of several European Union countries and member states from the ECT, which includes Portugal, where the treaty was originally signed. Following this withdrawal, other European Union nations such as France, Spain, and Germany have also exited the treaty, citing the conflict that I've already tried to expose to you between the ECT's protection of fossil fuel investments and their commitment to the Paris Agreement or the EU Green Deal. This mass withdrawal of EU states from the ECT also reflects a significant shift in the arbitration landscape, particularly as the EU seeks to reconcile investment protections with the environmental obligations. Also, this wave of withdrawals highlights the growing tension between upholding long-standing international treaties and meeting modern climate goals. On the other hand, another significant factor influencing investment arbitration in the European Union is the evolving judicial landscape, particularly in light of key rulings from the European Court of Justice. In my opinion, and I believe this is a general opinion, one of the most impactful decisions was the ACME case in 2018, where the European Court of Justice ruled that arbitration clauses in intra-EU bilateral investment treaties, BITs, were incompatible with EU law. This ruling has effectively dismantled the investor-state dispute settlement framework within the European Union for an inter-European Union disputes. And this casts a certain level of uncertainty over the future of investment arbitration in the region. In parallel to this, the European Union has also been advocating for a shift on the investor-state dispute resolution model towards what they say would be a more transparent and court-like system. And this has been presented as an investment court system. The investment court system aims to provide a more structured and transparent approach to resolving disputes while still trying to protect the investors' rights. Nevertheless, the full implementation of this system is still in progress and is still a project, and it remains to be seen how it will affect the existing and future cases that are running, for example, under the ECT or other investment treaties and contracts. Also, these judicial developments reflect the European Union's broader effort to align its legal framework with its policy objectives, particularly those related to environment protection and sovereignty. In light of these challenges, one of the questions that I think it's important for us to ask is what strategies can investors and states adopt to navigate the shifting landscape of investment arbitration within the European Union? Our insights reflect on three main topics. Firstly, would be to adapt to new regulatory environments. Investors need to stay informed about ongoing changes in EU law, more particularly as more countries withdraw from the ECT. Understanding how these changes impact investor protections would be crucial for managing future disputes. Another perspective would be to develop flexible arbitration strategies. Given the uncertainty surrounding traditional arbitration mechanisms, investors may need to consider alternative dispute resolution strategies, such as mediation or seek arbitration under new treaties that would incorporate sustainable clauses. And lastly, one of the other perspectives that I have would be that as the regulatory environment becomes more complex, investors should seek and must seek counsel from experts in EU law, environmental regulation, and in this way ensure that their investment strategies are aligned with the legal framework and sustainability goals. Ultimately, and also not wanting to take too much of your time, I would like to say that navigating these complexities requires a forward-looking approach that integrates legal, environmental, and economic considerations. The intersection of environmental concerns and investment arbitration represents a really complex and evolving challenge. As we've seen in cases such as the two that I've mentioned against Italy and Spain, states are increasingly regulating for environmental protection, and this can lead to investment disputes. At the same time, the European Union is moving away from traditional arbitration frameworks, as evidenced by the mass withdrawal that we are witnessing from countries to the ECT. And rulings such as ECMEA also represents this problem that we've been seeing. This considered, it's important that investors try to have an approach according to the strategies that I have proposed, and that I would also be very glad to discuss with you if you have any questions regarding this or any other topics. And with that, I'll leave the floor to questions. Thank you.
Thank you very much, Rita. And before we move on to our Q&A section, I just want to say a big thank you to Duarte, João, and Rita for your insights, for your expertise. It's been an incredibly engaging 53 minutes spent with you, so we really appreciate your time. We've had a few questions that have just come in, and looking at the time, we should have enough time to answer those. And hopefully, if there are any more questions, we might have a little bit of time to get those answered as well. The first question, and I would ask our panel, you can see those questions in the chat. The first one, do you see cultural differences influencing resolutions of international disputes? A fairly broad question there.
I can take this one. Yes, I do see a lot of differences in cultural terms as to the way the disputes are resolved. First of all, if we think of the great divide between the common law and the civil law jurisdictions, we will see that there are a number of practices, a number of doctrines that influence the way the dispute is resolved. For instance, if you are an arbitrator and you have a civil law mindset or a civil law background, you may be tempted to solve the dispute applying legal rules that the parties may have not raised during the proceeding. This is the so-called iura novit curia principle, where, as I said, in civil law countries, many arbitrators will apply this principle to search, analyze, interpret, and then apply legal provisions that have not been claimed and called upon by the parties. Another difference is that you may find is when it comes to challenge of arbitrators on account of the conflicts of interest. Whereas in countries like Portugal, it is very difficult to find situations where the parties do not know the arbitrator and parties and counsel, more accurately, the counsel and arbitrators do attend the same events, do belong sometimes to close clubs or groups of discussion, and this may raise some concerns about the independence and impartiality of the arbitrator. This may not raise those concerns because the country and jurisdiction is too small. On the other hand, if this is looked through the lenses of another international forum, such as New York or London, this will be absolutely unbearable and unacceptable. So it is my understanding that we should try to adopt as much as possible the international standards in what the fundamentals of the arbitration is concerned. And one of those fundamentals is precisely the independence and impartiality of arbitrators. When it comes to other kinds of questions, such as the way the witnesses are examined and cross-examined, you can spot a lot of differences as well when you compare, for instance, England and the US and France and Spain and Portugal, and the way the evidence is produced, and the way the tribunal is expected to have a more diligent or more, I would say, more proactive approach in the management of the case, and therefore going a little bit further and trying to find their own evidences and trying to and decide to run some sort of evidence production, such as expert determinations or the use of otherwise experts. So this has a lot to do with the cultural differences between the countries. Perhaps the second question, I think that João might be best placed to answer it.
Yes, indeed. So less than 2 minutes. The question is how might global events such as geopolitical tensions influence the approach to complex disputes in the future? I mean, having the example of space, it's not if how they can influence, it's how they already influence such decisions or such context to broader disputes. For example, just highlighting in less than a minute, competition for space domain, the current influence of dual use of space activities, either for civilian purposes or for defense and security ones, the improving, unfortunately, to some extent, the fragmentation of international cooperation, especially after the invasion of Ukraine, um, sovereignty claims and space resource competition on the surface of the moon, other celestial bodies, but also including subjects that are, of course, transdisciplinary or with multiple connections. For example, cybersecurity or space infrastructure, which are in the top of our agendas today, with cybersecurity threats to public infrastructures, to private entities, and of course the difficulty to have binding laws and binding treaties, because it's somehow decreasing the capacity of having this multi-state treaty that everyone can accept, because we do have more states, more private entities, that of course leads to more interests or different interests and different ways to approach their economic, political, and geopolitical context. So the involvement of the security and defense component more commercial and private sector involvement, and of course the current expanding fragmentation of international cooperation, in fact, will and are now already and will continue to influence disputes in general, and of course, space disputes are one of those to be affected for sure.
Brilliant. Thank you for that answer, Joao, and for your answer as well, Duarte. I'm just looking at the time. We will need to wrap up there, unfortunately. But once again, as I say, thank you so much for your time, for your insights and expertise. We really appreciate your knowledge and sharing your time with us today. We hope we can see you again soon. And to our audience, thank you very much for being with us today and for the questions that you've sent through. If you do want to get in contact with the panel, and we do encourage you to do that, we will be sending you their contact information following this webinar, so please look out for that. As for now, I wish you all a lovely rest of your day. Duarte, if you have any closing comments, I'll hand over to you to finish. Thank you.
No, not that much. Just once again, thank you so much to Modak and to you, Dan, and the whole team for your support and for allowing us to show a little bit of our passion for international dispute resolution. And we will stay in touch and available for any questions that the people in the audience may have. Thank you so much again.
Absolutely. The pleasure's ours. Thank you, Duarte. Have a lovely day, everyone.